We are in the middle of June. This video is going to tell us where we are in the Camp Lejeune contaminated water litigation. There's been a tremendous amount of activity with discovery and a court conference this week on the 12th. I want to give everyone an update about that and then kind of set the timeline for the next several months in the Camp Lejeune litigation. So without further ado, let's get into it.
This has been going on for 2 years now?
It's the most complicated case I've ever been part of. We're talking about 35 years at a military base, one of the most contaminated places in the entire United States, and that's by the government's own studies. What you need to know about the Camp Lejeune litigation today. We're going from 100 track 1 plaintiffs. These are the main injuries in Camp Lejeune. One of the great questions is how many different injuries can be caused by toxic exposure. That's going to be borne out over the course of the next potentially year or two. Mm-hmm. But these main injuries, like bladder cancer, Parkinson's disease, kidney cancer, that's where we're starting in the litigation. And the judge says, let's start with these big ones first. Everyone knows about that. So there's 100 track 1 plaintiffs. The agreement between the parties was, let's get that down to 25. And then from 25, we're going to get down even less than that. But the pool of potential trials is going to go from 100 to 25. And that is going to be 3 selected by the plaintiff side and 2 selected by the defense side. Plaintiff picks of 3 for each illness. When I say 3, there's 5 illnesses, so it's 3 for each. And then the defense, the U.S. government, will pick 2 from each. That's going on today. Plaintiffs' picks are going to be due tomorrow, and then defense picks are going to be after that.
Is that typical to narrow it down to that amount of cases?
This is a big pool because the big case over a long period of time with a lot of injuries, but it is common in a big litigation where you have a bellwether pool and maybe your bellwether pool is 20 people and then it gets cut down. So that's what we saw in AFFF right now. Mm-hmm. Their pool is getting cut from 25 to 6. Okay. In this case, we're getting go from 100 down to 25. That's happening right now. That's the biggest thing. There's track 2 illnesses, which are a number of other cancers, and then we're going to have track 3 illnesses. That's another update from the conference this week. It's another major update is what are the next group of injuries that we're talking about. Mm-hmm. Department of Justice is proposing track 3 illnesses as miscarriage, dental defects, hypersensitivity of the skin, and esophageal cancer. Plaintiff leadership group is proposing pancreatic cancer, esophageal cancer, scleroderma, multiple myeloma, and aplastic anemia. What we've seen in this case and what you see in a lot of cases, we put it out there. Sometimes there's some conversations with the judge, and then there'll be some kind of an agreement on what the next group of injuries that will be litigated. I do think the plaintiff's leadership group here, those cancers, multiple myeloma, aplastic anemia, these are specifically selected because there's strong medical evidence showing toxic exposure causes these illnesses. I think the plaintiff's leadership group will get several of those into the next group of cases being litigated.
Can track 1, 2, and 3 be ongoing at the same time, or is it something where track 1 has to conclude before the rest can follow?
So that's a great question I don't know the answer to. I think it could go either way. These major cases, it's easier to break them up into small parts. Mm-hmm. And then the biggest thing I think that has to happen is we have to have one trial. We have to have a trial. Mm-hmm. And that trial is probably going to be bladder cancer, kidney cancer, non-Hodgkin's lymphoma, or Parkinson's.
That's to set the bar for all the other cases.
Yeah, and the question there is, does that verdict set the bar for that injury only? Mm-hmm. Or does that verdict set the bar for multiple different injuries? And you may have to have 5 or 10 trials with some different injuries. But if all the verdicts are coming out the same, depending on the injury, maybe the judge or jury who's issuing these verdicts, assuming there is a verdict and not a defense verdict, maybe it's just the conduct so bad. And if you had to go through something like that, how much of a spread will there be between different injuries? That's one of the great questions, and that's really for the finder of fact to determine. And then we'll use these little data points to try to come up with a settlement matrix for everybody, an agreement where we don't have to do 1,000 trials, but maybe the idea is we do 5 or 10 trials, and that information allows for a settlement for everyone.
So this is a pretty significant update in the sense of, or this is really going to move these cases forward.
It is not lost on anyone. The fact that a majority of the plaintiffs are older, even the youngest plaintiffs. We're talking about the period from 1953 till 1987. Even the 18-year-old who was there in 1987 is
in their 50s,
late
60s.
50s. Yeah, late 50s. Most of the people, we're talking about bellwether plaintiffs. I was on the email thread yesterday. Bellwether plaintiffs that are 90 years old. They need to have their trial now. They're 90 years old. There's no guarantee they live to 91. And they want to know the outcome of their case, and they want their day in court. And what you see is time and time again, the judge saying, what is the plan to get these cases to trial? Magistrate Judge Robert Jones presided, and he said, what's the plan for the next 90 days? And the plan is you got to get down to 25 track one plaintiffs. You have to complete whatever outstanding fact discovery there is. And that's review the paperwork, take depositions of the doctors, take depositions of witnesses. That has to all be done within 45 days. And then the experts in the cases have to be disclosed. And once the depositions are done and the experts who are, we should talk about what are the experts going to do? The experts are going to say that this substance, whether it's TCE or benzene, it's my opinion based on science that this substance causes this injury.
Right.
I'm not a doctor. I can't say that. You can't say that. You need a scientist, a doctor, to explain to a judge or jury, the finder of fact, how this exposure causes that injury. The experts are going to be critically important. And that's going to be the next step. But once you have talked to all the witnesses and you have all the paperwork and you have the experts, the case is trial ready and you get a trial date.
It'll be interesting to see how many experts will be giving a statement.
Something that's also really interesting for the lawyers is a lot of the evidence that will be used by the plaintiffs is actually the government's own studies. There's a thing called ATSDR. There's been, this is a super fun site, there's been extensive studies done on the water, on the groundwater of Camp Lejeune. And the studies were done by the government, and the VA has accepted, it's presumed many illnesses are caused by exposure at Camp Lejeune. So what they're going to say or not say when they're confronted with their own studies will really be interesting down the road. A lot of these developments come out of the status conference. The next status conference is June 27th. We will try to continue to update the case. It's in a really good flow right now. The lawyers are working hard. The case is moving. It took a long time to get the Camp Lejeune lawsuit moving. It's moving now. I would expect more updates coming up on June 27th. You can subscribe to the channel. You can go to our website, Robert King Law Firm, under Camp Lejeune. We post the updates there, so it's easier for us to post the updates. If they're small, we just post them on the website, and then when we get major updates, we try to do the videos, and we'll keep doing that for the rest of the year.